The Civil Rights Act of March 1st, 1875 was the last piece of civil rights legislation of the Reconstruction period, and it would be the last piece of legislation dealing with civil rights to pass the Congress until 1957. And there were statutes passed dealing with civil rights, particularly with voting and the power of the Attorney General to intervene in cases of voting discrimination. There were statutes in 57 and 60, but nothing, I would say at least, of very much value. Okay, going back. The Civil Rights Act of 1875 guaranteed equal rights in public places, inns, public conveyances, theaters, and so forth, without distinction of color and or other distinction for that matter. An attempt to include a school integration clause did not pass at that time. 8 years later, in what are known as the civil rights cases, which were 5 cases involving the 1875 Act, the Supreme Court struck down the act by a vote of 8-1. And we'll read the civil rights cases, but not for some time. The act was held unconstitutional because the court held that the 14th Amendment only prohibited invasion by the states of civil rights, but did not protect the invasion of civil rights by individuals unaided by state authority. Even private interference with such rights as voting, jury service, or appearing as witnesses in state court were not, the court said, within the province of Congress. There was, and I'm going to leave out a quote from it due to time, there was a passionate and elegant or eloquent dissent by Justice Harlan at the time. As I think you know, between that period of time and 1957, there was very little progress and on the whole more regression in the area of civil rights. And it proved impossible to get a civil rights bill out of the Senate during that period of time. In the summer of 1964, after mass civil rights demonstrations for equality in Birmingham, after those demonstrations by African Americans, joined by some whites, were repressed brutally by police dogs and truncheons and things of that sort, President Kennedy announced a commitment to equality in public accommodations. Later on, a few weeks later, the administration sent to Capitol Hill an omnibus bill with provisions not only for equality in public accommodations, but to prevent discrimination in employment on the basis of race, religion, and gender. And the legislation, among other things, authorized the Attorney General of the United States to institute suits, to desegregate schools or other facilities, and to protect the right to vote. There followed a debate that took over a year before the legislation was passed, and much of the debate was framed as Americans do in constitutional terms, whether indeed Congress could do this under its powers. And it is so typically American that the debate didn't go very often, at least to those who were against, as to the issue, which was the clear policy issue, whether you make it impossible for African Americans to travel in this country or to find restaurants or to go to theater The debate was largely over whether Congress could do this. And Congress chose to pass this legislation under the Commerce Clause rather than the 14th Amendment. Why did they do that? Because the civil rights cases, as a precedent, appeared to make it impossible to pass legislation constitutionally under the 14th Amendment, so instead the Commerce Clause was used. And finally, in Heart of Atlanta Motel versus United States, which we will read, I guess, early next week, where a motel owner in Atlanta, whose motel served mostly transient interstate travelers, refused to serve blacks as required by the '64 Act. A unanimous Supreme Court upheld the 1964 Act based on Congress's plenary power under the Commerce Clause. There were concurring opinions, and Justice William O. Douglas and Arthur Goldberg in their concurring opinions said essentially, yes, we agree that the act is constitutional under the Commerce Clause, but it's also constitutional under the 14th Amendment. There was an accompanying case, which you only have a note on in your case book, and that was Katzenbach versus Mclaren. And that was a much more difficult case. It involved essentially a local restaurant, a barbecue, Ollie's Barbecue, which largely catered to intra-state travelers. But the court found, and the court found correctly under the precedents at the time, that even though the restaurant's customers were local, the restaurant purchased most of its food and supplies through interstate commerce, and therefore the '64 Act, as applied to Ollie's Barbecue, was also constitutional. Just one last word out of me, and that is, if you look at the handout, those of you that have it now, if you turn to the last page, you will see that what I reproduced was just one page of what was called the Green Book. And the Green Book, aimed at African American traveling, listed those places in the United States where African Americans can go. And in this case, the page I Xeroxed suggests that there were a number of places in Arkansas that you could go. And I would emphasize, though, since we're talking about segregation, we're not just talking about motels that won't take African Americans, but if you look under Little Rock, where you'll see that in Little Rock, there were tourist homes that accepted African Americans, there were beauty parlors, there were nightclubs, there were barbershops, there were taverns and garages. Well, think about that for the rest of the United States, where those facilities, especially in smaller towns, simply didn't exist. But if you were an African American, say on your way to visit a relative, for example, who lived in Rhode Island, a tiny little state, you don't have the page. But there were only 2 cities in Rhode Island where African Americans could find a hotel. And there were, in those 2 cities, only 2 places in each city where you could stay overnight. And finally, the 2 pages before, which somehow moves me much more. This was from a typewritten list. It's headed Restaurants in the District of Columbia. You have it? This was a typewritten list available to African Americans, and I suppose whites as well, listing the places in Washington, D.C., where African Americans and white people could sit down and eat a meal together. That there even needed to be such a list is appalling. But when you begin to look at the list, especially with the eyes of someone of 1962, and it looks like, you know, there are a reasonable number of places where you can eat. Well, once you begin to look at it, you have New Amsterdam Drugstore, for example, which was presumably something like a CVS, but had a fountain where you could get a sandwich and coffee. And you'll see how many of these places were cafeterias and the YMCA and pharmacies. So even in Washington, it was extremely difficult, again, to find places that catered to a mixed constituency. Well, that's enough out of me. If we may, let's look at the clip of the march.
The Gaston Motel. King had already left Birmingham, and no one was in the
Howard Glickstein was the staff attorney in the Civil Rights Division in 1963 and before that. And Howard went on from there to be first general counsel of the Civil Rights Commission of the United States and then staff director. He has been a formidable figure in civil rights for 60 years, I think. And I asked Howard, who honored us by being our dean, if he would give us his thoughts about what that day was like.
First of all, don't believe Dean Raful when he tells you that I worked on the 1875 Civil Rights Act. I was working in the Civil Rights Division at the time of the march. There was some concern that there would be violence, as this clip showed, and those of us working at the Department of Justice were told that we could take the day off without it being credited to a vacation day. We didn't have to come in. But I had nothing else to do that day, and I was on my way to work, and my bus that I took to work passed along the march route. And about 6 blocks from my final stop, I got off the bus and just to see what was happening. And there were crowds of people gathering. This was probably about 9, 10 in the morning. And they were, I think the group Peter, Paul, and Mary were rehearsing and singing nearby. And I decided that I'd see what was going on for the rest of the day. And I never went back to work that day. I remained at the march. That march was had some specific goals, but it was really born of frustration. It was nearly 10 years since Brown versus Board of Education had been decided, when there was great hope that there would be equality in this country and some of the barriers, discrimination would be broken down, and very, very little had happened in those 10 years. There'd been resistance to Brown. There'd been massive resistance in the South, and there was a determination that that had to be put to an end. As the movie suggested, this was not the first time there was plans for a march to Washington. During World War I, A. Philip Randolph, who was then the president, this was World War II, who was the president of the Brotherhood of Sleeping Car Porters, threatened a march on Washington. And first thing he did was speak to Mrs. Roosevelt about it, and she decided that that wouldn't be a very good thing to happen in the middle of the war. We needed unity during the middle of the war, so she went to her husband and said, "You have to do something about this. We don't want the march." And what President Roosevelt did was issue the first presidential executive order prohibiting discrimination in employment by government contractors. Not all government contractors working on the war effort. And at that time, many government contractors refused jobs to blacks, and if they did grant jobs, they were low-level jobs with differences in pay. So that march was avoided, but not the second march. Now, if the march was born out of frustration, those of us working in the Civil Rights Division and trying to do something about the discriminatory laws we had in this country were also very frustrated. There just weren't the adequate tools to bring about change. As Professor Morris mentioned, very little had happened in terms of legislation since 1875. The Civil Rights Act of '57 provided some additional remedies for voting, let the Department of Justice sue under some circumstances. The Civil Rights Act of 1960 provided some additional remedies, but still there were imperfect tools. There were not sufficient ways for the government to intervene in the civil rights struggle. In fact, one of the major complaints of groups like SNCC, Student Nonviolent Coordinating Committee, was that often when there were demonstrations in the South and the demonstrators were being beaten up, federal officials, primarily FBI agents, just stood on the sidelines and watched because they had no authority. The federal government had no authority to deal with local violence or something of this sort. And that was particularly frustrating. People didn't understand the nuances of federalism and what the federal government could do and what the state government could do. And what we in the Department of Justice did mostly in terms of legal work is we filed amicus briefs in cases. There were a lot of amicus briefs, and a lot of the cases that were brought by the NEACP and other civil rights groups, the Department of Justice filed the friend of the court brief, usually on the side, almost always on the side of the civil rights groups. And one area in which there was quite a bit of litigation was the sit-in area. People that sat in were arrested, often for trespassing or for disorderly conduct. Well, they just sat there, so it's hard to see how the conduct was disorderly. And one question facing the Department of Justice was whether to file an amicus brief and say that these arrests violated the 14th Amendment because it was state action, as the government was performing the arrests and depriving people of rights under the 14th Amendment. And that would have been a rather strong position to take. The government never took that position. In each of the sit-in cases, up until about '65, that went to the Supreme Court, the government took a very narrow position. I worked on a lot of those cases, and I mean, some of the positions where the indictment was improperly worded, and that's why the case should be thrown out. There were all sorts of just technicalities. It was so frustrating to do this because you felt that there were much broader issues involved, but we were taking these very narrow positions. And at the time, I thought that was outrageous, that we should be saying this violated the 14th Amendment. You can't arrest people for demanding equality at a lunch counter or in a hotel. But the Solicitor General, who was then Archibald Cox, believed that you should proceed very slowly. And in the long run, he might have been right, because there was massive resistance to the Brown versus Board of Education decision. And it took a long time before any progress to be made. On the other hand, and this was Archibald Cox's theory, when Congress passed a law, as it did with the Civil Rights Act of 1964 and the Public Accommodations Provision, when Congress passed a law, the feeling was it was much more likelihood that people would comply, that there wouldn't be massive resistance. And that is in fact what happened. The day after the Civil Rights Act was 64 was signed into law, many places in the South were integrated. So that might have been an appropriate theory.
Howard, could I just interrupt for a moment?
Sure.
Because I'd like to emphasize it. In the debate that went on over the passage of what became the '64 Act, apart from some constitutional arguments, there were many, many liberals who said basically you can't legislate morality. You can't make people like each other. It's just not going to work. People won't sit down with each other at soda fountains or whatever. And I thought, what I found absolutely amazing was that a year after the passage of the legislation, the act was enforced in the whole country. And whatever problems there were in enforcing other civil rights legislation, this was the most sweeping victory. I'm sorry, go ahead.
And it was a victory in an area where there were very, very great problems. The discrimination in places of public accommodation were a great embarrassment to the United States. There were many instances where foreign diplomats, mostly from the African country, were refused service at different places. And this was in the midst of the Cold War, when we were saying that we want to spread democracy throughout the world. Look what we do in the United States. And here people were being denied service. Professor Morris showed you a list of places where people could or couldn't go. In 1961, there were freedom rides in the South, and the freedom riders were beaten up in Birmingham and in Montgomery, Alabama. And the Justice Department brought a suit after that. We sued the Ku Klux Klan and the officials of Birmingham and Montgomery. And we had a bunch of us went down to Montgomery, Alabama to work on the case. And we couldn't stay in a hotel because some of the lawyers and some of the staff members were black. We had to stay at Maxwell Air Force Base. And part of that was for our protection, but the other part of it was that we wouldn't have been allowed in the hotel with an integrated group. So a major goal of that act was accomplished by eliminating discrimination in place of public accommodations. Professor Morris mentioned the act was passed under the, was sustained under the Commerce Clause. But when we started to draft the act, we were trying to find some basis for federal jurisdiction. And one of the first attempts was to draft a provision that said that it applied to any hotel or restaurant that was within X number of miles of a federal highway. So we were making that connection. And there were all sorts of problems of defining what a federal highway was and then deciding how many miles. And eventually, we didn't do that.
Howard, I've got to interrupt on this because I didn't say it and you didn't say it. But Howard was one of those who drafted the administration version of the '64 law.
Yeah, well, the work on that act, and I also worked on the Voting Rights Act, is an interesting commentary on separation of powers. A lot of the work was done in the Department of Justice and not in Congress. We drafted legislation. We drafted speeches for the senators and congressmen. We wrote the congressional reports, and it was all done in the Department of Justice. Very little was done by Congress. They would send over the materials, and the congressional staffs would look at it. But sometimes senators would deliver speeches that were drafted, and without having read them beforehand. And then when they were asked questions about what was in the speech, they couldn't really answer the questions. And I remember one occasion when, this was with the Voting Rights Act of '65, we had drafted a speech for Senator Kennedy, Ted Kennedy, and I went over to the Capitol Hill to give him the speech, and he took it from me, and I said, well, you're going to deliver it this afternoon? And he said, no, of course not. I need to have my staff review it. But he was one of the few senators that did some of his own work and had his staff review it instead of working on it itself. But sometimes when you read Justice Scalia's qualms about legislative history, maybe he's right about some of that, because there was one instance when the Civil Rights Act of 1960 was being drafted, when the Department of Justice was anxious for one of the provisions to be interpreted in a certain way. So we arranged for two congressmen to have a colloquy. One of them would say, now this provision provides that, and it means this, doesn't it? And the person on the floor would say, yes, and doesn't it mean this? And they went back and forth creating a legislative history, but they were the only two people in the House of Representatives at the time. So this was the legislative history of that provision in the statute. And there might be many others like that. But although the Title II of the Civil Rights Act of '64, the public accommodations provision, was very important, there were other important provisions too. There was a provision that allowed the Attorney General to sue to promote school desegregation. That finally gave the government an opportunity to do something about that. Professor Morris mentioned that there was an employment section in the version of the bill that President Kennedy introduced. It was a very narrow provision. It just provided that government contractors, it imposed some obligation on government contractors, and it did not provide for gender. The legislation did not provide for gender discrimination. In fact, when the Title VII, the section that deals with employment discrimination, was added in the House of Representatives, and that too did not contain a prohibition against sex discrimination. Well, one day the chairman of the House Rules Committee, Howard Smith, who was a real segregationist congressman from Northern Virginia, introduced a provision, amendment to the bill, that would add sex discrimination as one of the grounds of discrimination. And everybody, all the liberals, all the proponents of the bill were petrified. They felt that that would probably defeat the bill because people understood by then what race discrimination was, and they had some idea of what it meant and what it involved, but people didn't really understand what did sex discrimination mean. And as the law has developed over the years, it means a lot of different things, but there was great concern about it. So there was a big debate on the floor of the House of Representatives, and it was the liberal congressmen and women that opposed the provision adding sex discrimination. James Roosevelt, who was Franklin Roosevelt's son, who was a congressman from California, got up and said, if my mother was alive, I'm sure she'd be opposed to this. Congressman Sulla said, I don't know. Congressman Sulla was from Brooklyn. He was the chairman of the House Judiciary Committee and a very strong proponent of the Civil Rights Act. He said, I don't know what this concern is about sex discrimination. In my house, it's true, I have the last word, but the last word is yes, dear. I mean, they were joking about it. Some were serious, but the liberals were determined to have the sex provision defeated, but it was passed. And it didn't lead to the defeat of the Civil Rights Act. But another very important provision of the Civil Rights Act of '64 was Title VI, which prohibited discrimination by recipients of federal financial assistance. Now, this was very important and very symbolic. There were all sorts of programs around this country where people received federal money and then discriminated. They were segregated, or the minorities were totally excluded from the participation in the programs. There were even federal statutes at the time provided for separate but equal. They provided for some financial aid to white hospitals and some to black hospitals. And there was a case in Greensboro, North Carolina, where the NAACP challenged that provision of the statute. And ordinarily, if a federal statute is challenged as unconstitutional, the Department of Justice is supposed to defend it. And in this case, the Solicitor General confessed error and said that he couldn't defend it because it was unconstitutional. But Title VI was very, very important, and it became even more important in '65 when Congress passed a very wide-ranging legislation to provide financial aid to public schools. up until that point, there'd been very little federal money that went to public schools. That law was passed, and that combined with Title VI, which would have cut off the funds to schools that discriminated, prompted many of the southern school districts to desegregate, because they weren't going to desegregate if they were threatened with a lawsuit, because the lawsuit, by the time it reached the Supreme Court, there could be 3 graduating classes. So it didn't really, they weren't afraid of lawsuits. But the loss of federal funds, and there was a lot of federal money involved, was a very significant factor. And from 1954, when Brown was decided, until 65, there was hardly any school desegregation in the South. And in the next few years, there was a massive amount of school desegregation. And it was largely due to the concern about the cutting off of federal funds. So,
I've got to cut you off, or your successor here will do terrible things to me.
oh, he'll do them to me, not to you, but,
It's okay.
okay, no.
Go ahead, finish up.
I think that I've really gotten to the end of my remarks, but I did stay through the day of the march, and it was as inspiring as that little clip showed you, and you were just swept away by all the events of the day. And I never realized that I was participating or being witness to such a historic moment, but it turned out to be such.
Well, let me just say a couple of quick words before the end. I appreciate Professor Morris asking me to say a word. I think he asked me because if you've been in my office, you know that for the last, 30 years or so, I've had 3 large posters of Dr. King and the March on Washington on my wall, so it's meant a lot to me. I would say 2 quick things about the march for me personally. One is it was pretty clear to me right away that day watching the march about the power of nonviolence. There were 250,000 people, and there is a direct line from that march to the Civil Rights Act of 1964 and the Voting Rights Act of 1965. There's a direct line. Of course, the Supreme Court has managed to gut it's an editorial, Dean, has managed to gut the Voting Rights Act, but we'll talk about that some other time. So that next day or that next weekend, I remember asking my father if we could go to the local bookstore, and I bought a book by Mahatma Gandhi that weekend. And it was difficult for me at 13. I'm not nearly as smart as my predecessor or my successor. I'm sort of bookend. But I started reading Gandhi, who of course Dr. King read as well, and realizing the power of nonviolence. The other thing I guess I would like to say is a little different take. Because for me, my grandfather was very important in my life and was a brilliant guy who never finished high school. But for us, it started a long discussion about federalism. The march started that discussion that we continued for a long time. My grandfather was, I guess you'd call him today, he wasn't sort of a conservative or liberal, or he was sort of a rugged individual, maybe a libertarian, maybe that's what we'd call him today. But he really didn't want the government on his back. And yet he wasn't conservative. I remember we were driving in the car once when I was a kid with my grandmother, who was unfortunately very racist about the Japanese bombing Pearl Harbor and we saw a black man and a white woman walking down the street holding hands, and my grandmother said how terrible it was. And my grandfather, this is, early 60s, said that people should be able to date whoever they want to date. But we started talking, when was Heart of Atlanta Motel? 64. My grandfather and I started talking about the role of government, which you will study this year with a great professor, about the role of federalism. My grandfather was not such interested in federalism. And yet we started talking about it, and I remember talking about Heart of Atlanta Motel with my grandfather, who finally said to me after a year or two after the march, there is simply no other way to change America than to have federal legislation. He really had changed his mind on that. And this little crummy motel, which was a couple of blocks, 3-4 blocks off the highway, for the government of the United States to say it's part of interstate commerce is on one hand ridiculous, And on the other hand, it's the only way the country changed. And to have, for me, that discussion about federalism started over the lunch table every couple of weeks or so with my grandfather about the role of the government. And now we can study constitutional law and think about the appropriate role of the government. And it started with that march for me. The other thing I guess I would say with Dean Justice here is you get to, the nice thing for you is you got today to meet a hero, a real hero. That's what you can do with your JD, right, George? That's what you get to do. Not just if you're going to go into civil rights. There's lots of ways to change the world. But if, Howard Glickstein changed the world. He's a hero. A lot of our students don't get to know him because he's old and decrepit and doesn't move his head. But, he's a living legend. Yes, the March on Washington was stupendous. It was stupendous. But it was the next day, people with JD degrees, lawyers, sitting down and writing legislation, moving it through Congress, getting it signed by the president, and then getting it upheld by the Supreme Court of the United States. So, A, today you got to meet a hero, a real hero, and secondly, you get a chance to be inspired about your JD. So, go to the library and study. Thank you.
I just have a brief word here.
Jeffrey?
What?
You could just get on the microphone.
Oh. I have a very brief word, and that is I never quite put the march in the appropriate perspective for us, and that basically was this. The battleground for the 64 Act was the Senate. You had to get virtually every senator from a non-segregated state to vote for the act to get the act through. And the March on Washington and the fact that it occurred without violence had an enormous effect on the country and also had a significant effect on Northern Republicans. It was still liberal Republicans in those days from New York and New Jersey and places like that. And they were conflicted. Republicans generally in those days, Northern Republicans, were very sympathetic to civil rights, but they were very skeptical that this law was really a rather partisan law that the president was pushing so that he himself would get credit. That never had been my view from the inside, but whatever, this demonstrated to the Northern Republicans that there was a big constituency in the North sympathetic to this kind of legislation. And it made a very significant difference. The other thing, and the last thing I'd say, is the tragic death of President Kennedy also helped the passage of the legislation. His successor, President Johnson, put it front and center. And he was a man of extraordinary ability in dealing with Congress, and it may be the last couple of votes to get this thing out of committee, to end the filibuster, was the work of President Johnson. Well, I wish Howard, I know, could have gone on for hours and hours, and maybe there's some way we can get him to meet with you again, because he is such a joy and he has so many stories. Thank you. And willing to